bring in, though, my legal analyst guest to discuss today. I have Brian Silber, a trial attorney out of Florida, and of course still with me, Daryl Exum, who's also trialed some death penalty cases. I'll start with you, Brian, though, since you're new this morning. Thank you for joining me, but I want to get your take so far on what we've heard and maybe something that stuck out to you from those arguments, because the defense was really talking about some of the scope of what the prosecution could present now that this is a penalty phase and not the guilt phase.
Good morning. Thank you for having me. It's a pleasure to be back. So when I hear what's going on in court today, I hear the classic cat and mouse about the government trying to make as strong and prejudicial a case as possible to get what they're trying to get, and the defense trying to narrow that on the other hand and limit it. The court is correct. The government does not have to try its case in a vacuum. However, that does not mean they get to go over every fine detail to the umpteenth extent and really just pound and pound and pound away. You know, there's a balance that has to be had, and between the defense objection and the state's desire to delve further into this evidence, the court should find a happy medium. And that's what I think will happen here.
Certainly, of course, the burden of proof still on the prosecution to prove aggravating factors. Let's bring in my guest today, see what he thought about the judge's ruling, and the defense still trying to object again after the jury left the courtroom. Again, I have Brian Silber with me from Florida there. What did you think of that effort by the defense there right before lunch?
Well, I would characterize it a little different. It's not an effort. It's actually correct. You know, in a courtroom, we have to be very surgical about our evidence. There's no glossing over in a first-degree murder trial and just assuming that the witness is correct. Witnesses can testify about what they can testify to, and this is what we call a fact witness. This is someone that observed something, that saw something, and just like a video recorder, all that person can do is hit play and tell us what they saw and observed. It takes an expert to interpret that information and tell us, here's the probability of what it means versus the probability of what it doesn't mean. And this detective, I'm sorry, just does not have the qualifications to interpret the evidence. He can say what he suspected it to be, what he may have personally, in his lay opinion, non-expert opinion, believed it might be, but he can't tell this jury for sure what it was. That's the role of an expert. And it's no different than if you had a medical problem. You're not going to take ultimate medical advice from your friend or your cousin. You're going to talk to a doctor. And that's because a doctor has the expertise to explain the science and give an accurate opinion, not just look at what happened. It goes a bit further. And that's my problem with what's going on right here, and why I think the defense is doing a very good thing. It really chases justice when you see objections like this. It's a good thing.
Oh, yeah, it certainly makes sense given the circumstances. Maybe another ground for an appeal in this case. We'll have to see. Welcome back to Court TV Live. I'm Chanley Painter, and we've been watching along for the penalty phase in Andre Warner's trial. Now, he was convicted of murdering Adam Hilaire back in March of last year, but because of the coronavirus pandemic, the penalty phase was delayed more than a year. Now, a new jury is sitting to listen to evidence and determine whether or not Andre Warner will be sentenced to life or the death penalty. I'm going to bring in to talk about the day's testimony so far. Trial attorney and former prosecutor Brian Silber still with me to talk about some of the key evidence. We heard from family members, roommates, the ex-girlfriend, investigators so far today before the lunch recess. One of those that really stood out to me was the ex-girlfriend. Of course, she testified in the first trial for the prosecution, and Brianna Harper is key for the state, not to offer more character evidence, but about some of the evidence in the case, the hats that Adam Hilaire loved to wear. She testified in the trial that he wore them 24/7. He would take it off maybe to go to sleep, but that was it. He wore them all the time. Speak to me about how important this type of testimony is, not only to prove that there was a robbery here, but possibly also for the penalty phase, some of the factors for pecuniary gain, right?
Well, I think we need to really address the real message of this evidence. You know, it would have been very simple for this prosecutor merely to lay out every single hat on a table and have the witness identify, yes, these are the hats that my boyfriend used to wear. I'm very familiar with them. We were together many years. He wore them all the time. But that's not the route that was taken by the prosecution. Instead, they published these very prejudicial photos that I think made the victim extremely endearing to the jury. And that was a very sharp trial move. It was totally admissible. I don't think I heard any objection by the defense. So really what the prosecutor was doing was using, yeah, we got to talk about these hats. We want to tie it together. But by the way, jury, here's this human being that was brutally murdered. And here's a snapshot into his personal life where you can see him having very intimate moments, personal moments, happy moments, smiling moments. It's extremely valuable for her to send that double message. And I'm actually surprised the defense didn't stand up and make an objection. But look, it's not my case to try. They know their case. There's a bigger plan, I'm sure, at play, a bigger strategy. But those were just some of my thoughts, what I observed.
Yeah, I noticed that too, Brian. Great call, because you're seeing photos of the minor child, that they were together, even though Brianna
Right.
didn't testify to the fact that they had a child together. You can see it in the photo. So yes, very strategic there, and no objection that we know of on the record from the defense. Another point of today that stood out to me, because during the trial, the guilt phase, this was a huge piece of evidence for the prosecution, and that was the jailhouse phone call the former detective, was playing before this jury this morning about gunshot residue. And the defendant is on the phone with his grandfather asking him about GSR, and he says, I showered plenty of times. Within 24 hours, there's no way they would have found gunshot residue on me. Again, that's huge again for this jury to hear. Not sure if they had a transcript, though, because it's a little difficult to make out that piece of evidence, but certainly you could argue it in the close, right?
Well, I had a hard time hearing it myself, and I think if the prosecution was going to rely on this evidence, it would have been good for them to produce a transcript so it can be read in context. But I got to tell you, these jail calls are such a big problem for defense counsel. The inmates know they're being recorded almost, and you would be surprised at the things that are said. I myself have gotten phone calls from inmates trying to have a consultation over the phone, and I have to tell them to stop talking about their case. I'll go see them in person. I hate that circumstance also. I just don't like the fact that you have a person talking to a loved one about their case, and it's being recorded for court purposes. Obviously, that's lawful. But I feel like it's not the greatest way to try a case, especially since we don't have context. We can't tell what the people were thinking when they said what they said. But that's why it's circumstantial evidence. But definitely that was a plus for the prosecution, for sure.
Certainly here, and I know that you're a former prosecutor. What would be strategically moving forward, real quick? I know this is the penalty phase, but it's a new jury. What are you wanting to introduce to make sure they pick up on? Because you almost have to prove the crime again, right? But also these aggravating factors.
Well, the prosecutor has to be very careful because she has a different panel now, and all the thoughts and memories of seeing the original evidence in trial do not exist in this jury's mind. They didn't happen to see that, which raises an interesting question. I don't know how that will be viewed later on if there is, a death penalty imposed, how it will be reviewed. But she does have to tell the story of her case. She can't have her jury wondering, is the death penalty appropriate in this case without having discussed, the underlying offense. So I think she's doing a good job.
Absolutely. She did a great job in the first trial as well, winning that conviction against Andre Warner.